Give the gift of thoughtful conversation this holiday season with a membership to the Commonwealth Club.
Hello and welcome to the Commonwealth Club. My name is Laura Bazelon. I'm a law professor at the University of San Francisco School of Law, where I direct two clinics, a criminal and juvenile justice clinic and a racial justice clinic. I'm thrilled to be back moderating another amazing Commonwealth Club program, this time with Linda Greenhouse, who needs no introduction, but she is, of course, one of the most respected, if not the most respected, analyst and interpreter of all things United States Supreme Court. She is now a lecturer in law at Yale University after spending 4 decades at the New York Times. And we are here to talk about her new book, which is called Justice on the Brink: The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and the 12 Months That Transformed the Supreme Court, which could not be more timely given what's coming up in the news. Okay, so Linda, welcome.
Happy to be here. Thanks, Laura.
I'm going to jump right in because tomorrow is a big day at the United States Supreme Court. The court will be hearing oral arguments in a Mississippi case. There's a statute whose constitutionality is at stake. That statute bans abortions except in extremely limited circumstances at 15 weeks. So can you bring us up to speed on the facts, the legal questions, and what is at stake here?
Yeah, and I'll just back up to the subtitle of my book, which you read, which ends with 12 months to transform the Supreme Court. And one piece of evidence of how the arrival of Amy Coney Barrett in the court's last term transformed the Supreme Court is the fact that this case is on the court's calendar at all. Because what Mississippi did in banning abortion after 15 weeks of pregnancy, in other words, months before a fetus is viable, was breach the firewall that has protected the right to abortion for almost 50 years, since Roe versus Wade and since the Planned Parenthood case in 1992. That is to say, before viability, the state can walk on their hands and recite all kinds of crazy stuff and listen to inaccurate informed consent and all that kind of thing. But at the end of the day, the woman has her right to terminate the pregnancy. So that's just been a key thing. And red states have been trying for the last number of years to breach that firewall or to enact other unconstitutional statutes. And lower courts, of course, have struck them down, as a very conservative appeals court struck down the Mississippi law. And the court has refused to take these cases. Why? Well, because why would the court take these cases? These laws are flatly unconstitutional. So all of a sudden, the case is now about to be argued tomorrow. There's only reason for the court to have granted Mississippi's petition, agreed to hear the state's appeal, is there's a critical mass of justices, maybe 5, maybe 6, who want to change the law. There's no other reason to have taken the case. They turned down all the other cases like this. So that's where we stand. And Mississippi has various arguments. Things change. This law is, for the good of women, which is a very strange thing for the state of Mississippi to say, because on any measure of outcomes for pregnancy and early childhood, Mississippi ranks at the very, very bottom of the 50 states. So they seem to care a lot about 15-week fetuses, but they sure don't seem to care very much about babies once they're born, or the women who become mothers in the course of childbirth. So it's a question about the court's fidelity to precedent. It's a question about, the deeper question, of course, is about the role of women in society. We can take this any way you like, but it's a very, very important moment for the social, political, law-related history of this country.
I want to take it in several directions, if that's okay with you, and stay here for a minute. You talked about how this case is really about a flagrantly unconstitutional statute. We've been here before, and there have been people who have said, okay, Roe is doomed at various different points, including the Casey decision in 1992. But as you say, the composition of the court here is qualitatively different. And I guess I have to ask you, in retrospect, how you feel about what you call Justice Ruth Bader Ginsburg's spectacularly bad bet that by not resigning when Obama was president, she could stay long enough to have another Democratic president appoint her successor and go on in that time to be, as you say, the notorious RBG and be known for her fiery dissents. I guess the question is, at what cost? You talk about how she was one of the only people, maybe the only justice after Bork, who, when asked during her confirmation hearing about her opinion about Roe versus Wade, actually answered the question directly and said that she supported it. She said, quote, "Women's ability to realize their full potential is intimately connected to their ability to control their reproductive lives." That very principle, as you indicated, seems like it's at stake here. A question I have for you is if whether you think that there are a majority of votes that agree with that position. Do you think that these Trump justices agree that women's ability to realize their full potential is intimately connected to their ability to control their reproductive lives?
I don't think there's a majority of votes on the court for that proposition. Mississippi makes the strange argument that, well, maybe that was true back at the time that the court decided Roe, because women didn't have many opportunities for advancement in the workplace and so on and so on. But now things are great. Women can do anything. And so why do they need the right to abortion? I mean, it's hard for me to articulate the argument because it makes so little sense to me, actually. But Laura, I'm going to push back on the way you started that question.
Sure.
Because, there is a school of thought, and your question reflects it, that, we'd be safe if only Ruth Bader Ginsburg had retired back when Obama was president. Where to begin with that question? We'd be safe if only Democrats had mobilized enough to elect Hillary Clinton in 2016. We'd be safe if there would have been some way of pushing back against Mitch McConnell's lockup of the Supreme Court vacancy when Scalia died. A series of events. And so, I think the worst you can say about RBG is that she placed a bad bet. And her bet was Hillary Clinton was going to be elected in 2016. How many of us did not assume that? And, if she had managed to hang on for another 4 months, President Joe Biden would have been able to fill the vacancy. So there's so many contingencies. And I'll add one more thing. Had she retired when the male professoriate rose up and told her to retire, we wouldn't have had her voice. We wouldn't have had the, quote, notorious RBG. We wouldn't have had her mobilizing dissenting opinions for the last 7 or 8 or 10 years. And personally, I would have missed that quite a lot. She was speaking to history. And sure, she was speaking in dissent. She was already in dissent. So, I just want to put those thoughts on the table for people who think, oh, if only RBG had retired when we told her to, we would have been in better shape.
I'm glad you pushed back. I'm going to push back on me a little more and say, I feel like there is a fair amount of blame to go around. I mean, one thing I'm curious to know your opinion on is the Democrats, I think, utter failure to transform the judiciary when they had the chance to do so. That, Obama's appointees, first of all, weren't that numerous. And second of all, had no way to match the ideological rightward tilt of Trump's. He appointed these very centrist, basically prosecutor and private law partner folks to the court. In no way sort of was that at all a counterbalance or the liberal alliance that we know of the past. That was not a priority. Mitch McConnell 100% made it his priority to shove these justices through and judges on the lower courts, which in some ways is more important considering that the vast majority of cases never make it all the way up to the Supreme Court. And I don't know what you think about this, but there's certainly an argument that by failing to prioritize the judiciary, by failing to be brave in their selection of nominees, by failing to come up with some kind of counterbalance to the Federalist Society, it's actually the Democrats who have nobody but themselves to blame, and trying to shove an older justice out of the way and then blame her for not retiring is really, I think, a cheap shot and passing the buck. That's the counter, right?
We are on the same page, my dear. I completely agree with you. And, it's a deeper question. I mean, it goes back to Bill Clinton, who was very lax in filling the vacancies that he had. The Republicans have been so strategic and so intentional. So while Obama was president, he was pretty slow off the dime to fill vacancies himself. Once the Republicans took back control of the Senate, they held seats open so that when Trump came in, there were dozens of vacancies. And then all the senior, not all, many of the senior Republican appointed judges on the lower courts who had been appointed back to Reagan took senior status, which opens up a vacancy. There was a wave of everybody going senior so that Trump was able to fill more than 200 vacancies on the lower federal courts. Now, I'll just say this, that lesson was learned by Joe Biden, who of course had once been chair of the Judiciary Committee, and his chief of staff, Ron Klain, who was his chief of staff back when he was in the Senate. And, President Biden hasn't gotten sufficient credit, I think, for the fabulous way he's been proceeding in filling the vacancies that he has. He's now up to, I think, the 10th round of judicial nominations, and these are fabulous. They are getting confirmed. I mean, the Senate is awful close, but they're pulling out all the stops, and these nominees are getting confirmed. And so, whatever happens for the remainder of the Biden administration, he is leaving a very decided and important legacy on the federal courts.
I agree. And I could stay on this topic all day. One final point about Biden is that he's actually appointing former federal public defenders and civil rights attorneys. And that is, for me, as a former federal public defender and a lifelong advocate for people who are accused, a welcome relief, because the bench is just crowded to the brimful with former AUSAs, former DAs, former partners at these giant firms. And it's just, we badly need not just diversity in terms of the way that you normally think of diversity, which we badly do, especially after all these Trump appointees, just one white man after another, but we also badly need practice experience. And actually, you point out that the only person who's ever tried a case who's currently on the Supreme Court is Justice Sotomayor. But the questions are already flooding in, and I'm still not done with Mississippi. So I want to ask you my question about Mississippi and then the ones in the chat. Okay, so in terms of what we're looking at tomorrow, what kinds of questions should we expect from, I think, what we could consider maybe the three crucial votes here, or four, which would be Amy Coney Barrett, Brett Kavanaugh, Neil Gorsuch. Those are the Trump appointees. And then, of course, John Roberts. What are you looking for in the questioning? And is that in any way going to tip the hand of these justices and what they might be thinking about?
Well, of course, the money question is the viability question, because my opinion, you could get an argument going on this, but my opinion is that if they breach the viability, what I call firewall, Roe against Wade is functionally overturned. They may not say, in fact, I'd be a little surprised, not shocked at this point, but maybe a little surprised if we see the words in the eventual opinion, Roe against Wade was wrong the day it was decided, it's wrong today, and we hereby overturn it. What I'm quoting, by the way, is what Justice Kennedy said in Lawrence against Texas, which overturned Bowers against Hardwick, which was the anti-gay rights opinion from 1986. In 2003, they repudiate that. They find that the due process right gives the right of LGBT people to their intimate relations. And Kennedy said, I think this is an exact quote, Bowers against Hardwick was wrong when it was decided. It is wrong today, and we overturn it. Will we hear that about Roe? I think probably not. But if they breach that firewall, 15 weeks, why not 10 weeks? Why not the Texas vigilante law, which is 6 weeks? Why not? I think I read the other day that Arkansas has a bill pending for 0 weeks. The one thing that the question that is most commonly asked by a justice of a lawyer appearing before the court is, what's your limiting principle, right? Because the court knows it's not just deciding the dispute that's in front of them. They're deciding If we buy what you're selling us, what about the next case and the case after that and the case after that? The Supreme Court is making law, not just resolving disputes. So what is the governing principle if viability isn't there? And I'm kind of hard pressed to think of one. And so I think that's a functional overturning of Roe. And what I want to hear from the court is how they're going to approach that question.
This is a question from the chat, and the person asks you, does the Mississippi law outlaw chemically induced abortions, the morning after pill administered by the women without a prescription requirement?
Wait, I want to make sure I heard that. For self-administered abortion, was that the question?
Yes.
Well, the states are going after that. So under the FDA label for medical abortion, the 2 pills that are prescribed, I believe the label calls for, based on the scientific evidence, that those pills can be used for abortion up to 10 weeks of pregnancy. So Texas has passed a law, didn't get much notice, kind of in the shadow of SB 8, that limits the use of medical abortion to, I believe, 6 weeks. Now, I think there's a federal preemption question there. I mean, the Food and Drug Administration sets the rules for the approval of medication, and the FDA prevails. I don't know whether there's somebody's bringing a lawsuit. I assume somebody is. So, the states are going to try every way they can to make it extremely difficult for women to obtain the pills and, whatever. Will they be obtained? Yeah, they will. I mean, women in Texas are going over the border to Mexico where you can buy anything in a local drugstore. And there's various contingencies being played out by within the pro-choice community. But, that's not the kind of regime we want in the country. Abortion, I believe, is the most common medical procedure in the country. As you know, I mean, the statistics are that about 1/3 of all American women will have an abortion sometime during their reproductive lifetime. So, we're talking about a very common procedure that would be driven underground by, a vote of 5 or 6 justices. I don't know. This is not the country that you and I grew up in.
I was going to save this question for the end, but I really can't help myself, which is when you talk about this particular issue in your writing now, your post-2008 writing, when I hear you speak publicly, you're a very passionate advocate. What I hear you saying is you're a passionate advocate for women's rights. And maybe I'm going a leap too far, but also that you're a passionate advocate for the right of bodily autonomy. Do you feel like that was something that you were not really able to do when you were covering the court's abortion jurisprudence as a reporter at the New York Times, because you were in a role of reporting, whereas now you're somewhat removed? And in fact, part of your job is to write an opinion column for the New York Times, I think twice a month. So are you freer to express how you actually feel now? And if that's true, was that a reason in part why you left, so that you could actually have more of an opinion on issues like this and other issues?
No, I actually left because they put a very good buyout on the table. And I rightfully deduced there was never going to be such a lucrative offer again. So I put my hand up and took it. So no, I mean, the questioner is quite right. Being a daily news reporter and being an opinion columnist are 2 different things. So yeah, I mean, I've always felt strongly about the right to abortion, and people who want to know more about how I feel about it can read a little book I wrote kind of dealing with this issue. It's called Just a Journalist, came out in 2017. But I'll say this, I mean, even within the kind of zone of objective daily mainstream reporting, which is something I believe in. Mm-hmm. Wherein does objectivity lie? And my strong belief is that the role of the daily mainstream journalist is to inform readers of the true state of affairs insofar as the reporter understands the true state of affairs, which is to say, go back to the period when states were passing laws that required doctors who perform abortions to have admitting privileges at local hospitals, right? And the states would say, this is for the sake of women's health. We're trying to protect women. Now, we knew that wasn't true. They were trying to shut down the clinics because they knew that in these states, doctors simply could not get admitting privileges at hospitals, A, and B, that doctors who perform abortions don't need admitting privileges at hospitals. So many of the stories said, oh, on the one hand, states say it's for women's health. On the other hand, the clinics say, no, it's not. Well, in my opinion, that's bad reporting because those stories needed to inform readers, by the way, doctors who perform abortion don't need admitting privileges. They can't get them. This is a cynical effort to shut down the abortion infrastructure that allows women to exercise their constitutional right. So, I think there's not maybe such a bright line between those two kinds of writing if the daily mainstream news reporter realizes that she can't allow herself to be used by the kind of PR machine for one side or another side. Just let the readers in on the facts. I mean, look at the voter ID issue. When that first emerged from the Republican Party, oh, we need voter ID because there's a lot of fraud. Well, no, actually, there's no fraud of the kind that a voter ID law would intercept. They're just not. I'm not going to show up at the polls and say, hello, I'm Laura Bazelon, I'm here to vote. I mean, that's like ridiculous. We know it's ridiculous. But so many stories said, oh, the states say it's because there's fraud. Well, it's true. That was true. That's a true fact. The states were saying that, but they weren't saying it with honesty. So that's a long answer to that question. You obviously touched a button of mine, but it's something I invite people to think more about when they think that there's a sharp line between fact and opinion.
You touched on this in your answer when you mentioned voting rights. This is another question they're pouring in from our audience. They want to know, in your opinion, what other issues besides abortion should we be most aware of with the current makeup of this court?
I would name religion. And in my book, I talk a great deal about the trend, which really accelerated during the term that I'm writing about, toward the privileging of religion above all other claims in civil society, above a claim not to be discriminated against on various grounds, whether LGBT or disability or whatever, the right to have public health experts tell us what to do during a pandemic. You want to limit the number of people who can gather in an indoor space. Oh, but if it's a church, we have to overturn that, and this kind of thing. So there's a case that's going to be argued next week, a case from Maine about the right, about the channeling of public money to pay tuition at religious schools. And I'm sure that the religious schools are going to prevail in this case. And that'll mark the culmination of a project of the Roberts Court with case by case, a couple steps at a time, at a time, that it's really going to upend what had been the kind of settlement that when it comes to parochial schools, yes, the government can provide, busing or secular textbooks or release time for students to leave class and go to their religious organizations and get religious education, but you're not going to directly channel public money to cover religious school tuition. And that's where we're at right now. So I would call that to people's attention. Second Amendment, gun rights, big case argued earlier this month. And And voting rights, as you said, the voting rights case that came down at the end of the last term that I'm writing about, the Arizona case, was very disturbing and it's going to make it very difficult to bring successful challenges to the voter suppression efforts that are accelerating around the country right now. So there's a real irony concerning the role of John Roberts as Chief Justice. Had Hillary Clinton won, been able to fill the vacancy that Mitch McConnell had deprived President Obama of the right to fill, there would have been 5 justices to John Roberts left, and Ruth Ginsburg would have been the senior associate justice on the left, and she would have been in charge of that block, and John Roberts would have been in a minority in his own court. Of course, that didn't happen. Now, Trump having gotten 3 appointments, John Roberts has 5 justices to his right. And so he's got to scramble if he's going to be the, quote, leader of the court, in fact, as well as name. It's a very tough spot to be in. Now, I think people who describe or think of Chief Justice Roberts as some kind of squishy moderate in the middle of the court, that's not correct. He's very conservative. He's the justice who brought us Shelby County, that cut the heart out of the Voting Rights Act of 1965, all kinds of conservative decisions. So that's kind of not the point, but he's in a tough spot because he's got very aggressive, eager beavers to his right. I could name 2, Sam Alito and Neil Gorsuch. And, he's the one with his name on the door. It's the Roberts Court. He's also a student of history. He's got to be concerned about how history is going to judge the court in his time. He's been Chief Justice since 2005. He's not a newcomer to the court. He's in a tough spot. And I think the way to understand it is to get over the notion that there's always somebody in the middle of the court who controls the outcomes. I mean, obviously, there's always someone in the middle of the court, and there's an odd number of justices. So there's always going to be a, quote, median justice. But what does that mean in practice? And I think we're also used to thinking about, it was the Kennedy court. Kennedy was never in dissent. You always had to pitch your argument to Kennedy. Before Kennedy, it was the O'Connor court. Before O'Connor, it was Lewis Powell in the middle. But before Lewis Powell, there were a group of justices in the, quote, middle of the court, 3 of them, maybe 4 of them, who could go one way or the other way, depending on what the subject was of the case, who couldn't be necessarily predicted. And I think we can predict a lot of conservative outcomes from this court, but I don't think we need to waste our time kind of identifying who's the leader of the Roberts Court. I think it's much more of a composite than a one-man show.
Do you think, though, that Roberts, because of what you said, that he has his eye on history and the legitimacy of the court, is going to do what he can to cobble together near majority opinions wherever he can, try to limit the 5-4 splits, and maybe try to find narrower ground upon which the court can agree to kind of prevent a real lurch to the right that would maybe delegitimize and overly politicize the court?
Well, I think it depends on what case we're talking about, for one thing. He's got his projects, and certainly one of them, he really doesn't like the Voting Rights Act of 1965. And there was nothing moderate or nuanced about the Shelby County case, and there was nothing moderate or nuanced about the Arizona case that they decided in July. It was an Alito opinion, but Roberts was fully on board there. I think on religion, we get into the Philadelphia case that was decided last term, has not been kind of fully understood, but I think on religion, he's full steam ahead for raising up religious exercise and kind of forgetting that the Establishment Clause is also part of the First Amendment. On abortion, we'll see. He kind of threaded a needle in the most recent abortion case, the June medical case 2 terms ago. But we kind of haven't seen the end of how what he wrote there is playing out. It may well be overtaken by events, depending on what they do with Mississippi and with Texas. So I'm not fully persuaded that he's going to moderate all those things that you and I might like to see moderated.
I think it does make sense maybe for us to pause and you to talk about the significance of the Philadelphia Fulton County case, because I think it's been somewhat overlooked. And it's interesting both because of the substance, but also because of how the majority opinion came together in Amy Coney Barrett's role.
Yeah, it's a fascinating case. I actually write quite a lot about it in the book. So this was a case about religious exercise and LGBT discrimination. So Philadelphia has a clause in the contract that all of the private agencies that it contracts with to do various services sign that requires them not to discriminate on various grounds, race, sex, religion, sexual orientation. So it turned out that a Catholic social service agency in Philadelphia that had a contract with the city to find foster parents for children who were in the city's custody, refused to consider same-sex married couples as potential foster parents. And Philadelphia said, you've got to follow this contract. And the social service agency said that would violate our religious belief. We can't follow it. So this came up to the court as a question about whether the court should overturn an important precedent from 1990, a Scalia opinion called Employment Division against Smith. So Employment Division against Smith holds that when you have a law that's a general law, it's a neutral law. It doesn't single out religion, applies to everybody, of general applicability. The free exercise guarantee of the First Amendment doesn't give you a right to opt out, doesn't provide you an exemption from such a law. That holding, Employment Division against Smith, has been very, very unpopular on the religious right. Huge social and political pressure to get the court to overturn it. So that was really the question in the case called Philadelphia against Fulton. The court did not overturn it. Roberts, actually, you got to give the man credit. He pulled a rabbit out of a hat. He said, well, we don't have to overturn it because actually this contract was not a neutral contract of general applicability. It contained a potential exception, that there could be an exception to the non-discrimination clause. Now, P.S., it was an exception that had never been used and was just sitting there with empty words, but there's an exception, and that means that Employment Division against Smith doesn't apply. The social service agency wins, the city loses, and Roberts got 9 votes for that. I'm here to say that Justice Ginsburg would not have put up with that charade, but anyway, the rest of them did, except Justice Alito wrote a very long, very angry opinion saying this was our chance to overturn Employment Division against Smith. We didn't do it. We wimped out. It was a concurrence, not a dissent, because he agreed with the bottom line, which was that the city loses. But it was such an angry dissent that, of course, it raised the question of had he once thought he was writing for the majority, but we have no way of knowing that. So what's very interesting, and the question that Laura posed is, Amy Coney Barrett did not join Alito in his angry opinion. She wrote her own opinion, and she wrote very little during the term. This was the most important thing she wrote during the term, I think it's fair to say. She said, before we go ahead and overturn something, we better make pretty sure we know what we're going to replace it with. And we don't know. And so we're not going to go down that route. And I fully subscribe to the opinion written by Chief Justice Roberts. So, there's a couple ways to read that. I chose in the book to read it as a kind of a declaration of independence, that she's like Sam Alito, take a memo. You don't get my vote. You know, we have a lot in common. We're both judicial conservatives. We're both conservative Catholics, but my vote is not yours. And, you know, we'll see. I mean, she did the same thing about a month ago. A case came up on the court shadow docket, the emergency docket, from a group of healthcare workers in Maine who were being required as a condition of keeping their job to get the COVID vaccine. And they said, oh, we have a religious objection and we want the court to intervene. The court did not intervene over the dissenting opinion of Justice Alito and Justice Gorsuch. And Justice Barrett again said, you know, this is not the time and place for us to brazen our way into this unfolding dispute. We don't know enough about it, and we're just not going to take up that cause right now. It doesn't mean they might not take it up later. There's a lot of cases in that pipeline. But so twice she has kind of pushed back against Alito's aggression. And it's very interesting. Just 2 data points. We don't know enough about her. But, you know, as I hope is clear, I really have an open mind. I'm eager to see how she reveals herself in the very, very consequential position that she finds herself in. It's very interesting.
One area of the law where I'm interested to see where she comes down, particularly because she wrote a very interesting opinion dissent on the Seventh Circuit concerning a tangentially related issue about the right to bear arms. And that's what I wanted to ask you about next is Second Amendment jurisprudence, which, you know, up until Heller had really been almost a non-existent issue before the court. And then after Heller, they have turned down case after case that has presented them with the opportunity to expand the right to bear arms beyond what they said in that case. They've now taken up a new case out of New York, and it looks like it could be extremely consequential. And I'm wondering how you think that case is going to come down, what we can expect in terms of what Clarence Thomas has called this second class right, whether it will attain first class status, particularly in light of the fact that guns are so very, very much in the news these days in the United States.
The week or the month that they agreed to hear this New York case, and as you suggest, it's very much like the abortion case. They had turned down case after case until they, I think, were confident that they have the votes to do what the conservatives want to do. The very week they took it, there were something like 3 page 1 gun massacres in various parts of the country. You know, this is really a time to take up a case that will enlarge the ability of people to walk around with concealed weapons, which I think is going to be the outcome of this case. So it just seems like a crazy time for them to be going down that road. But as you suggest, the conservatives led by Justice Thomas and Justice Alito have been pushing. And I have to think that it was the Chief Justice who was sort of holding back. Amy Barrett comes on the court. Now, you mentioned her dissenting opinion in a case called Cantor on the Seventh Circuit. I don't read that case as some other people do to show that she's kind of some kind of gun nut. It doesn't say that. It's a very nuanced opinion.
I agree. It's very subtle. Can you explain why?
Very subtle and, you know, pretty darn good opinion. The question in that case was the constitutionality under the Second Amendment of the federal law that prevents people convicted of felonies from carrying guns. And the convicted person in this case had been convicted of a white-collar offense, Medicare fraud. And, you know, he never had been a physical danger to anybody and didn't figure to be one in the future. So he brought this lawsuit challenging the constitutionality of what's called the felon in possession bar. And the law was upheld by the Seventh Circuit, the majority of the panel, and she wrote a dissenting opinion that basically goes back to sort of common law about the law of who could have a gun, who could be barred from having a gun. And she kind of played it out that this individual with this particular profile was not the kind of person who would have been barred from owning a gun. It was, pretty interesting. But I don't think it says anything about whether she's fully on board the Thomas and Alito position that basically anything goes. Well, we'll see. The case was argued a month ago. The argument did not look good for the New York law, which was being challenged. It's a law that says that in order to get a license to carry a concealed weapon, you need to show not only that you're a person without a criminal record who knows how to handle a gun, but that you have a special need for self-protection that requires you to be able to walk around with a concealed weapon. There's something about your situation that distinguishes you from the general law-abiding population. I think a half a dozen other states have such a law. Most states don't. Most states are more relaxed about it. And they say simply, you've got to show you're not a criminal in order to get a license to carry a concealed weapon. So New York's a bit of an outlier. But, a question came up, well, what about a concealed weapon on the subway? There have been, shots in Times Square within the last, couple of weeks. So it seems to me the timing is terrible, but I think the writing's on the wall as to how that case is going to come out.
This next question from an audience member has to do with the role that the Supreme Court could play for those of us who are worried that the United States is headed toward an autocracy. And I guess I could add on to that, this idea that, they've been rather Trump averse. He appointed these three justices. He said, the election's going to end up in the Supreme Court, and I need people who are going to install me as president come hell or high water. That didn't happen. Does that mean we should be hopeful that even though this is an extremely conservative court and he appointed 1/3 of the people on it, we should be confident that they are going to be a bulwark against autocracy and against flagrantly unconstitutional attempts to, say, steal another election?
Well, I don't think we should rely on the Supreme Court saving us from ourselves, really. And, I think it was a pretty close call, actually. As it turned out, the court, including the three Trump justices, did not do Trump's bidding. Something that, enraged him. And I think he's still going around announcing, I fought for these people and where were they when I needed them, kind of thing. So the whole thing was very ham-handed and the cases were badly presented. Some of them were just kind of ridiculous. Even a Trump-appointed judge on the Third Circuit, Stefanos Bibas, said, we need some kind of evidence, and there's no evidence here, that kind of thing. But that's not to say that better presented cases in the future could get enough votes. I mean, I'm not confident. There's this theory out there that that a majority of the court has never accepted, but made its first emergence in modern times in the 2000 election case, Bush against Gore, that state legislatures really have the last word on election procedures. So what was happening in the run-up to the election a year ago, the 2020 election, was that it was state courts, or in some cases governors, but basically state courts that were expanding the time limits for mail-in ballots and so on against the will of the Republican majority legislatures. And, I think there's going to be a lot of effort to kind of constitutionalize the ability of state legislatures to write the final rules, no matter what other organs of state government think is called for. And with the kind of gerrymandering we see going on right in front of our noses on the basis of the 2020 census, states are going to be state legislatures are going to be pretty solidly in Republican hands. And so to privilege the legislatures is to embed the Republican, power over elections, and that's certainly something to watch very closely.
I wanted to ask you about the court and race. It seems to me, at least when I look at the barbs that are going back and forth, particularly between Roberts and Sotomayor, that the issue of race on the court is just as polarizing as the issue of race is maybe in the broader public. I'm wondering if you can talk about that in the context of affirmative action jurisprudence, where you think that's headed, but also in particular, these two justices and their very diametrically opposed views about how to deal with racial inequities in our society.
Yeah, so there wasn't a race case in the last term by happenstance. I mean, the Arizona voting rights case obviously touched on race, but it wasn't directly about race. The kind of cobbled up challenge to Harvard's admission policies reached the court early in the term, and the court kicked that can down the road by asking the Biden administration to give it its views. I mean, that was just, I think, the court saying, okay, we've got abortion, we've got guns coming up this fall. We don't need affirmative action on top of that. They didn't need to ask the Biden administration for advice. It was kind of silly. I mean, if the court had granted review in that case, the Biden administration would have been perfectly free. In fact, it would have been perfectly expected to file a brief telling the court what his views were anyway. The court may well yet take that case, the Harvard case, or the University of North Carolina case, which is also pending. And so they could take it, rather soon, maybe even in time to decide this term. So it's still a very live issue. But to your specific question, yes, I mean, John Roberts and Sonia Sotomayor had quite a set-to in competing opinions in a case from Michigan back a few years ago. It seemed to be a lot of bad blood there. Yes, it is a polarizing question, but I think there's now a solid majority to get rid of affirmative action if the right case presents itself. I would be very surprised if affirmative action survived a kind of a head-on collision at the Supreme Court, which is not to say that any specific case might be that vehicle. The Harvard case would be a bad vehicle because there was an extensive trial, extensive fact-finding by the district court, upheld by the Court of Appeals, showing that Harvard did not, in fact, engage in racial discrimination in its admissions policies. But there's blood on the water, and there'll be more cases for sure.
On a somewhat related topic, when then President Trump nominated Amy Coney Barrett, they had a big ceremony in the Rose Garden, which of course ended up being a super spreader event. And he very quickly pivoted from talking about her intellectual achievements and qualifications to talking about why it was so important to have her as the devoted mother of 7, and in particular, the mother of school-age children. That was something that had never happened before with a female justice on the court. I'm wondering what you make of those comments. Do you think that is an important qualification? Do you think that is something that folks should take into account when they're nominating women and mothers to be judges?
No, I mean, I think it has nothing to do with anything. And I don't think Trump thought it had anything to do with anything, but it was his way of, kind of making her very appealing to the country, right? And she was very appealing to the country. So, it was a kind of a subliminal way, I think, of bringing her religion, her devout Catholicism, into the frame. The question that can't be talked about. So it was, kind of a subtle move from a very unsubtle politician. And it worked, right? Because if you manage to sit through any of the confirmation hearing, every Republican senator praised her motherhood and marveled at her, I don't know, her fecundity or whatever, but it just made for a kind of a silly show.
Yes, although to be fair, it wasn't just the Republicans. Dianne Feinstein did a fair amount of gushing herself. And I wonder too, at least when it's coming from the Republicans and it's coming from Donald Trump, if there is a more implicit argument being made. And that argument really goes to this point that Justice Ginsburg is so well known for, which is saying that a woman's autonomy and her future and her accomplishments are very much tied up with her ability to control her reproductive life. And it seems like holding up as an example, a mother of 7 is trying to kind of pointedly refute that and say, well, no, you can have as many children as you want. And still, don't worry, ladies, you can ascend as high as the United States Supreme Court.
Well, that's interesting. That's even more subtle than I gave Trump credit for. Yeah, I mean, that's just interesting. Maybe that, I mean, what I would say was religion was the elephant in the room. Mm-hmm. And you mentioned Dianne Feinstein. So when Amy Coney Barrett was nominated in the spring of 2017, she was one of Trump's first nominees for the federal appeals courts. Dianne Feinstein interrogated her about whether she would be able to set aside her religious beliefs and do the job of judging. And Feinstein said to her, I'm afraid that I think this is an exact quote, the doctrine lives loudly within you.
I think the dogma, the dogma.
Sorry, you're right.
It was quite ham-handed. Yeah.
Yeah. So, from Amy Coney Barrett's point of view, I would thank God that Dianne Feinstein said that, because it propelled her up to a kind of a level of almost victimhood of, that she was the victim in her confirmation hearing. Of course, she got confirmed. She wasn't much of a victim, but of anti-religious sentiment expressed by the senior Democrat on the Senate, or a senior Democrat on the Senate Judiciary Committee. I think that phrase, the dogma lives loudly within me, it showed up on, T-shirts and mugs and, in the religious community. So in a way, it put Amy Coney Barrett on the map. So fast forward to 2020, and she's nominated, and the Republicans were loaded for bear because they assumed that the Democrats were going to do a repeat. But something really unusual happened. The Democrats stayed on script, and the script called for them to make the issue not Amy Coney Barrett's religion, but Amy Coney Barrett's vote in the Affordable Care Act case, which was going to be argued in November within weeks of her then presumed confirmation. So every Democratic question, they stayed way away from religion, was about the Affordable Care Act, leaving the Republicans to be kind of, foaming at the mouth with their rebuttals on what they had assumed would be religious attacks on her. But the attacks never came. But the Republicans couldn't walk away from their own talking points. It was very funny if you have a kind of a skewed sense of humor. And I kind of go into this in the book because I found it pretty darn striking. So, the religious issue was never really joined. It's the last taboo in our society. You can talk about people's sexuality, people's gender identity, people's all kinds of things that used to be considered so personal, it would never be discussed. But talk about religion? No. So that's the lesson that emerged from this, I think.
And why is that? Why is it the last taboo?
Well, that's above my pay grade. I mean, but it's just my observation that, that's a really good question, but you have to ask somebody smarter than I am. But I think that, I think there's no doubt that I'm right as an observer of the passing scene. It's the fact that there are 7 Catholic justices, I'm including Justice Gorsuch, who now is an Episcopalian, but he had a Catholic upbringing and in fact went to the same fancy Jesuit boys prep school that Brett Kavanaugh went to. I mean, so 6 of the Catholic justices, those other than Sonia Sotomayor, happen to be from the conservative end of the Catholic spectrum, right? I mean, Catholicism in America is a big tent. There, I'm not assuming that everybody, sits in the same part of that bus, but the conservatives on the court do. Why is that? And what I say in the book, which is my belief, people can argue with me about it, is that Catholicism has become the proxy for how would you vote on Roe against Wade, right? I mean, every president since Reagan has run, every Republican candidate for president since Reagan has run on a party platform, pledging them as president to appoint judges and justices who would overturn Roe against Wade. I have to leave out Donald Trump because, of course, in 2020, in 2016, the Republicans, I guess in 2020, the Republicans didn't even bother to have a platform. So I can't say he ran on a platform. But anyway, a president can't really ask a potential nominee, by the way, how are you going to vote on Roe? If asked such a question, a potential nominee could not answer it. So you use the religion as a proxy. And that's why all 6 of the conservative Catholics have been named by Republican presidents. And that's where we are. It's a very surprising outcome, really.
We only have time for one last question, and it's this for me. I am so curious about how you have stayed on this beat since the 1970s and what it is about covering the Supreme Court that has kept you so interested and captivated over the years. And I say this particularly because you didn't actually go to law school. Now, of course, you have a master's in law from Yale, but you're not a trained lawyer. And I'm wondering if that's part of it. And if in some interesting way, maybe not being a lawyer is an advantage, has proved to be an advantage for you. But regardless, I'm curious to know what it is about this beat that has kept you so interested for all this time.
Yeah, no, I don't think it's a matter of not being a lawyer. I've had certainly a lot of adult education in all these decades. I started out wanting to be a political reporter, and I was in my early years at the Times. I covered the state legislature in Albany, New York, and that's what I thought I was doing. And ending up covering the Supreme Court was a bit of a happenstance. But what's kept me interested? Well, the court is really a window on the country. It's not divorced from politics. I never thought of it as divorced from politics. And so anyone who's interested in how the country works, I think would of necessity be interested in the role of the court and what the court was doing with the issues that reach it, because these are issues that are roiling the country and troubling people in some degree. So I feel like I've had a ringside seat on the unfolding of the American story for the decades that I've been deeply immersed in the life of the Supreme Court. And I feel very lucky, actually, to have had that opportunity.
Well, Linda Greenhouse, I think we are the lucky ones. And I just want to remind everyone, if you've not already bought this book, to immediately pick up a copy. It is called Justice on the Brink: The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and the 12 Months That Transformed the Supreme Court. Thank you so much for being with us, Linda Greenhouse, especially in this incredibly exciting, tumultuous, and cataclysmic week on the Supreme Court. I wish you the best of luck on the rest of your book tour. Thank you so much for stopping by and being with us at the Commonwealth Club. And yes, I just wish you all the best. And thank you so much for this wonderful conversation. I'm Laura Bazelon, and we are now at the end of our program at the San Francisco Commonwealth Club. Thank you so much for joining us.